Good evening, ladies and gentlemen. A very warm welcome to today's Current Legal Problems lecture. My name is Dsouza. I am one of the editors of the Current Legal Problems lecture series and journal. I'm also chairing today's lecture. And I will also oversee the Q&A session that will follow the lecture itself. Our speaker for today is Professor Antje du Bois-Pedain, Professor of Criminal Law and Philosophy and the Deputy Director of the Center for Penal Theory and Ethics at the University of Cambridge. Professor du Bois-Pedain has published extensively on transitional justice, criminal law theory, sentencing, and the philosophy of punishment. Her current project reconstructs the foundations of criminal liability based on a Pufendorfian analysis of human agency, and her monograph on transitional amnesty in South Africa was published in 2007. Before and mostly after that time, she has also published 6 edited collections of essays, and she's the author of a plethora of articles and essays in both English and in German in leading outlets across the globe. I personally have known Professor du Bois-Pedain since 2008, when she was one of the persons that taught me on the Cambridge LLM module on the philosophy of criminal law. And looking around, it's good to see some of my own students on the philosophy of criminal law module that I teach here are in the room. So there's generational knowledge being passed down. Antje also took me on as her PhD student a couple of years later. We were debating whether I should mention this, but I was actually her first PhD student. She has, you will be pleased to know, not been dissuaded by that experience. She has others now. And I can say now that I have known her for long enough to have no hesitation whatsoever to say that she is a brilliant and creative scholar, a generous supervisor, and an incisive commentator. Her lecture today is going to be titled Against Pro-Tanto Wrongs in the Theoretical Armature of Criminal Liability. And in terms of the format, Professor du Bois-Pedain will speak for about 35 to 40 minutes, and we follow that with between 10 to 15 minutes of Q&A. We realize that's quite short. It may be the case that we won't be able to get your question in. If that's the case, or if you prefer not to put your hand up and ask a question on the record, do feel free to catch us outside in the hub outside there, where we will have a drinks reception immediately after the lecture, so you can ask further questions there in a slightly more informal way. Now, I'm sure that you, like me, are looking forward to Antje's lecture today, and so without further ado, I will cede the floor to Professor du Bois-Pedain.
So, Mark, thank you very much for this nice introduction. I've put my title more simply now, and the simpler version of my title is Why Criminal Law Theorists Shouldn't Work with the Notion of a pro-tanto wrong when Building an Appropriate Structure for Criminal Liability Assessments. And when I was working on preparing the lecture, I realized that behind the topic of this lecture stand 2 really big questions. How does morality hang together? And how does the criminal law hang together? And these are importantly interconnected questions, but they are not the same questions. And so criminal law theory has always struggled with how it is going to address the same material that morality addresses, that is to say, human conduct, in a way that is appropriate for the criminal law and for the criminal courts. Now, there was perhaps a time when these 2 big questions were sitting closer together than they do now. And if that's right, then the history of criminal law theory is also a history of differentiating out the criminal law from the moral law and criminal law assessment from moral assessment. Now, in one respect, it's undoubtedly the case that the history of criminal law theory is a history of increasing differentiation between moral assessment and legal assessment of conduct. And that is the respect in which the need for that differentiation arises from a public law conception of criminal law and from the allocation of the response to certain norm violations to institutions representing the state in a criminal law context. So, to put the same point differently, the criminal law's distinctiveness in part arises from criminal law's connection to the exercise of coercive force through public institutions. And that connection requires an in-principle separation of criminal law practices from interpersonal practices of moral assessment and criticism. So that is, for instance, why we have criminal prohibitions, not just moral principles and expectations, and why we have criminal sanctions, not just moral disapproval and practices that express that disapproval at the end of a criminal conviction and punishment. But of course, this separateness of criminal law from moral practice does not mean that there are no connections. There are. And that is because the kind of evaluation that is of the center of criminal law assessment shares some of its point with a moral assessment of behavior. And that shared point is that both of these practices seek to establish whether the agent did a bad thing, including why and in which ways it was a bad thing to do, and they are concerned with how badly the doing of that bad thing reflects on the agent. So, by way of general introduction, I want to stress that we need to understand how and why criminal liability assessments should differ from interpersonal moral assessments, particularly in the pathway on which they are reached, and what the commonalities and parallels are. And today, I want to focus on one example where, to my mind at least, the ferrying across of a notion familiar for moral discourse, that of a pro tanto wrong, into criminal law assessment wrecks a proper construction of how an instance of human conduct is appropriately assessed under the criminal law. And I want to show how and why that notion stands in the way of building a structural scaffold towards appropriate criminal law assessments of human behavior. Now, in this lecture, I will speak of acts or actions interchangeably with conduct. So I use these terms in a wide, untechnical sense that includes omissions. And I also draw no technical distinction for the purposes of this paper between acts and actions. What I mean by these terms, conduct, act, action, is an instance of human behavior that can properly be subjected to moral evaluation. And what is distinctive of such conduct, I will explain by drawing on Pufendorf's view. But it's also a terminological stipulation that I want to ask you to bear in mind. So, what is it that I'm going to do in this lecture? I think you can see it also from the big subsections in the handout. First, I'm going to talk about how moral assessment works. I will introduce you to how this 16th century scholar Samuel Pufendorf thought about it. And I will develop 2 points out of what he explained about how moral evaluation of conduct occurs and why it is possible. And then I will bring in the question, how does moral evaluation happen communicatively? And in that context, I will talk about another scholar, Luis Duarte de Almeida, and I will mostly call him just Duarte. I think that's okay, and it's also shorter and easier to pronounce. And how he explained in a slightly different context, where his concern was about making sense of how Hart and Austin thought of exculpations, how that fits with how Pufendorf suggests we evaluate conduct morally. And then at the end of that section, I will make a suggestion about how the notion of a pro tanto wrong sits in a scheme of moral evaluation. And then I'm going to tell you about how Andrew Simister wants to put the notion of a pro tanto wrong to work in criminal liability assessments. And I'm going to look at his view in quite some detail, but ultimately my destination and my target when it comes to his view is what he takes to be the upshot of his view in terms of when what Mark actually for good reason calls a rationale-based defense, a justification or an excuse of the type of a duress defense. Simister takes the upshot of the pro tanto wrong view to be for these kinds of defenses that they shouldn't be available to an agent who was unreasonably mistaken, culpably mistaken about the factual preconditions of the defense. And he furthermore thinks that it follows then quite naturally It's just cashed out by the theme, the structure that he has built, partly by drawing on the notion of the potential wrong, that this cashes out as preserving the liability for the initial offence which was under investigation against a particular agent, and that will usually be a crime of intent. It certainly matters when it is a crime of intent that doesn't have a sort of a cognate crime that is seen as much more serious than another crime that one could look at that is only based on negligence. So towards the end of my lecture, in a part that is still under development, I will then talk about where exactly is the bug in this and how do we fix it. So that's what we're going to do, or what I'm going to do in the next 20 minutes or so. So let's look at Pufendorf. Pufendorf saw moral evaluation as connected to a practice he called imputation. So in the history of philosophy, imputation refers to the evaluation by which an event in the world is assessed, constituted as a human deed. Through imputation, that event is constituted as a human act which can be subject to moral evaluation. So Pufendorf, who lived from 1632 to 1694, took the distinctive markers of human agency to be that the behavior is concurrently goal and norm oriented. These are really his criteria for agency. So what he has in mind, and I think a lot of people realize that behavior for which we can be subject to moral evaluation will be goal oriented. You know, I have an aim, I pursue an aim. The thing that Pufendorf sees, and that a lot of philosophers since him have actually started overlooking, is that human beings also always have a sense of what that goal status is in moral terms. It's not just instrumentally useful, like when I take a sip of water, but I would have a sense of, say, there is only one glass of water in the room and I suddenly grab the one that Mark already has his fingers on. There is also then a processing on my part of the knowledge that that is actually his water, and that there might be something questionable in what I'm doing precisely because it is his water and not my water. So Pufendorf says that the possibility of moral evaluation arises because of human beings' embeddedness in a cultural wrong, in a cultural practice. And through those cultural practices where human interaction occurs, we realize, we are, in a sense, we learn what it is okay to do, what it is not okay to do. We learn about the moral status of conduct. And so he talks about specific objects of cognition that we get this, which he calls moral entities or entia moralia. So something that one can think of as moral facts or moral truth. And he says human beings are active in that realm whenever they engage in goal-directed behavior, because in all of these situations they use reason, and in their reasoning they draw not merely on the ability to identify goals and means to ends, but also on their knowledge of the moral worth of these goals and of the moral law. And so for him, goal-directed human activity without such normative orientation is unthinkable. And then, because of this normative dimension of human agency, we can morally evaluate it, and in a sense across two dimensions. So first of all, we can ask whether the behavior that the agent engaged in was in accordance with the agent's moral duty, supererogatory, or in violation of moral duty. So that is sort of one dimension, one question we can look at. Was this an okay thing to do, or was it a bad thing to do? did the agent violate moral norms? Did the agent show insufficient, faulty, normative orientation in what they were doing? But he says we can also ask a second question, and that's, in a sense, a somewhat different dimension of evaluation. And that is the question, how badly does the doing of that thing reflect on the agent? How well or how badly? So that is the dimension of merit or demerit arising from the thing that they have done for the agent as a person. An agent who has done something supererogatory can be more or less blameworthy for doing what he did. As a criminal law scholar who drew on Pufendorf's idea once said, well, you might have someone who jumps into rough waters to save a person at risk to their own life. And you would think of them as heroes until you learn that the only reason they did so was because the parent of that child who couldn't swim was holding a gun to their head and say, jump or else. Right? We might still think they've done a good thing, they've done a great thing, in fact, but to what extent will you now say, oh, and we really have to admire them? If it wasn't their voluntary choice to save that person, becomes more questionable. So all I want to do with this example is just to remind you that there is the question about the status of the conduct as such. Was this a good thing to do, a bad thing? Was it in violation of moral duty? Did it go beyond the call of duty? Was it just in line with moral duty? And the evaluation of the doing of that thing in relation to how it reflects on the agent. And again, it is quite interesting to see that sometimes even the doing of a thing that is in line with our duty, not a violation of our moral duty, can reflect badly on us. If we do it for nasty or selfish reasons, we assert our right, but just, by way of, in order to wind other people up, not because we care about the right at all, then, it doesn't reflect badly, it doesn't reflect well on us to act in this way, though there was no violation of duty in what we've done. So that's how moral assessment works for Pufendorf. And now let's think about how moral discourse happens in interpersonal situation. And that was the bit that Duarte de Almeida was particularly interested in. So he was interested in a situation where I say, he did this. And the response that the person who did it might then bring was, yes, but hold on a minute, hang on, you just need to see that what I did was something I didn't mean to do, I wasn't really aware of, of the further consequences. All sorts of additional aspects can be brought up by the person who did it to respond to what I've said when I said, you did this. And Duarte says all these kinds of responses, these fuller descriptions of the event that the person who did something might bring up, are in a very broad sense defenses, in this sort of non-technical interpersonal sense. And what do these defenses do? Well, if they work, then, says Duarte, and he's quoting Hart and Austin in this context, if the defenses are accepted, then the accuser would be unwilling to repeat the accusation. But, and that's the interesting point, not because the statement, you did X, is no longer true. It's not withdrawn as a false statement of fact. It remains a true statement of fact. Rather, what is withdrawn or what falls away is the accusatory valence of that statement of fact. So as Duarte explains, when D did X is uttered as an accusation, it is uttered with the implicit claim that D's having done X makes the bringing about of certain negative consequences appropriate. And when the fuller description of the event has deflected the accusation, then it is still true, it's still the case that D did X, but it is now, as we might say, just a fact. It is no longer a fact that calls for an unfavorable reaction towards D, no longer a doing of X of which D will be accused. So what has happened then? We might think of it as describing what has occurred as a neutralization or neutering of the negative moral balance of the doing of X. And what's interesting about that, looked at in this way, there doesn't seem to be a difference in the way in which successful justifications and successful complete excuses operate. On that level of responses to an accusation which they successfully deflect, they are, in a sense, at the same level. And we shouldn't be surprised by this, because we can think of all these things that a person might bring up to deflect the accusatory import of you did X as speaking to one or the other of these dimensions of moral imputation, of moral assessment that Pufendorf suggests. It can speak to whether what X was really a bad thing to do in the situation. It can speak to whether it really is so much to the demerit of the agent in that situation. And there is no technical separation, there is no, in a sense, stages to those assessments. And that, I think, is something that happens in morality and is a way in which, by now at least, moral discourse differs from what happens in the legal liability analysis. Because in the legal liability analysis, we have a sort of a step-by-step scheme where you pass through an evaluation of conduct as unlawful before you reach questions of whether blame attaches to the conduct. And so it also is, I think, an interesting way of sort of thinking about how in the history of, and that is just an aside, of how the common law developed. I think initially courts were not really thinking of themselves, as being in the business of subjecting conduct to a technical legal evaluation about whether X committed this clearly defined offence, which and thereby breached the law. Their sense was much more a sense of general moral assessment. And we can see this, for instance, when we think that historically the courts could say, well, doesn't really have to concern us whether this was a clearly prohibited thing to do. It was clearly such a bad thing to do, and the doing of the thing reflects so badly on the agent that we declare it's a crime, right? So it happened in a very different way. And this way of thinking is still floating about in some contexts in the criminal law. We haven't quite moved to the point where we keep these two types of conduct assessment separate. Now, how would, in moral discourse, the notion of a pro tanto wrong be understood? Now, I think it would most plausibly be approached by giving it a sort of a quasi-procedural sense. So one can think of this initial accusation, he did it, as pointing to wrongdoing only in a pro tanto sense. But what does that then mean is that it's understood that in this initial making of an accusation, the accuser momentarily and provisionally holds that what D did he holds it up to him as a full-fledged instance of blameworthy wrongdoing, but it's understood by both of them that the accusatory sting may be withdrawn or reduced, pending the introduction of further potentially deflecting circumstantial facts into the discussion. And the accused is, by the very fact of the accusation, invited to bring those up. So that would mean that the reference point of this initial accusation, if we understand it as a pro tanto wrong, is a provisional or a defeasible judgment of wrongdoing. It points to something that is sort of the opening gambit in a continuing discourse of accusation and deflection. So, can we make any use of that idea in the more technical context of criminal law? That gets me then to the next part of the paper. How does Andrew Simister use the pro tanto wrong notion in his depiction of how a criminal liability assessment works and what it should do? So in criminal law theory, the pro tanto wrong view is a view about what it means for the criminal liability assessment that the defendant's conduct has met the definitional requirements of a criminal prohibition. And I put the first quote here from Simister's book, where he says, in declaring that fying is a pro tanto crime, lawmakers make it the case that fying is a pro tanto wrong, and if done without justification, wrongful. Now, it seems to me that this phrase pro tanto crime is something that we should just ignore. We should simply understand that what he's talking about is that in setting out the definitional requirements of a criminal offence, and what they set out there is then fying, lawmakers make it the case that fying is a pro tanto wrong, and if done without justification, wrongful. So is this just provisional, the opening gambit move that we know from moral discourse? It could be, but it seems to me that Simister, well, it could be that he doesn't give this notion any substantive weight. And that is actually what I was thinking first when I was reading the second quotation that I have put onto your handout here, where he says, by itself, the actus reus mens rea combination is merely a pro tanto offence. The offence proper is committed not merely by D satisfying the actus reus and mens rea requirements, D must concurrently lack a defence. Thus, the offence is the complete package. Finally, what is prohibited, unlawful, lies between the pro tanto offence and the offence proper. It is the impermissible wrong, the pro tanto offence, when done without justification. Now, to my mind, this formulation is actually quite peculiar. I'm not so sure what Simister means when he says what is unlawful lies between the pro tanto offence and the offence proper. If he doesn't want to give this pro tanto offence notion any substantive weight, then it would be more natural to say that the offence proper is the pro tanto offence when it is unlawful. So we haven't yet made a judgment about whether the unlawfulness of the defendant's apparent offending when we have established the pro tanto offence. So then this pro tanto offence notion wouldn't carry any moral weight. It would be a moral nothing. But Simister doesn't really want that. And that is, I think, what becomes clear when we look at the next quotation, which I put on your handout. He says, the actus reus mens rea combination gives the pro tanto crime, or that's basically conduct that meets the definitional requirements of a criminal prohibition, its primary specification. It articulates what wrong is in play. Justifications may qualify that wrong, but they do not modify its basic character. At most, they carve out exceptions, which reduce the normative space the wrong occupies. And that is then an idea that Simister does work with when he applies this kind of thinking to the context of an agent acting in self-defense. And he says, and that I didn't put on your handout, I just sort of put it here as by way of illustration, to claim that one acted in self-defense when injuring the victim is not to deny that the interests protected by the relevant offence were set back. It's not to claim that the duty not to injure V was cancelled. Rather, it is to claim that there were supplementary reasons why doing so was on that occasion permissible. In an important sense, however, those reasons do not themselves directly engage the law. It is not prohibited to protect oneself. What brings the law into play is that in doing so one injures another. And then he does put the notion of conduct as a pro tanto wrong to do some further work in the criminal law evaluation of conduct that he has categorized in this way. And its main downstream consequence concerns when we see how unreasonable mistakes of fact made by a person who thought they acted under a recognized defense affect the availability of that defense. And in that context, Semester puts a lot of weight on the following idea. We can fairly ask defendants who chose to perpetrate a pro tanto wrong to explain themselves and to bear at least an evidential burden in doing so. Now, that point is actually someone that one can also underwrite from a perspective that looks at what happens here in the shift from an offense to a defense, as I explained it drawing on Duarte de Almeida's work. Yes, we might think that somebody who has, against whom the accusatory "you did X" can be directed, has some explaining to do to take the accusatory sting off. But that doesn't necessarily mean what happens when that explanation falls short to some extent, which it would have done in cases where the person made an unreasonable mistake. Mm-hmm. They have qualified what they've done, but they haven't reached a point where we would say, okay, I understand then it was okay for you to do this. We wouldn't quite go that far. In some sense, there was still something not okay about what they've done, but we haven't yet established that in the criminal law context, it needs to play out the way that Semester wants it to play out. A few lines later, he says, when a person's excuse rests upon a mistake, it is legitimate to expect that the mistake be a reasonable one, just as it should be for justifications. I thought that was surprisingly loose language here. It is legitimate to expect that the mistake is a reasonable one. What does it mean? Is it just a soft sense? Someone could justifiably criticize the defendant for having made that mistake? Yes, that's true. But is this really a point about the criminal law? The criminal law should not make any adjustment to its initial judgment that there is the full accusation, in a sense, of that particular wrong in play because you couldn't deflect it completely. He certainly wants to make the criminal law assertion, and that is the last quote I put on your handout here. It will be argued that the case for distinguishing pro tanto wrongs from their justification rests in part on the thought that justifications do not merely cancel the underlying duty. By that very token, however, the case for segregating excuses is even stronger. It is stronger because once unjustified, a pro tanto wrongdoer is a wrongdoer simpliciter. She does a wrong, and an unlawful one at that, whether or not she is excused. Now, again, this was a puzzling statement for me, and what puzzled me about it was that the first sentence appears to speak to something of potential moral import, namely that D's underlying duty not to engage in conduct that meets the definitional requirements of the prohibition is not merely cancelled. But then, in the next sentence, all that Simister draws from it, because he starts the next sentence with by that very token, is a case for segregating excuses. He doesn't say from what, but from the context it seems that he wants to segregate them from offense elements. If this is all what he means, then the argument he appears to foreshadow here is that excuses for him cannot put in doubt that D's conduct in the circumstances constituted an unjustified wrong, and that is something that I think we also wouldn't necessarily feel like putting into doubt. So we haven't yet encountered any substantive argument when and on what basis an excuse is to be denied to the wrongdoer, just that one should keep this separately from the question whether the offense elements have been met. So it seems to me that at the end of the day, the idea that the excuse must be denied to the wrongdoer, and it is technically an excuse, even when in a context of trying to access a justificatory defense like self-defense, the person makes an unreasonable mistake. Then at the end of the day, they're not going to be justified for what they're doing, even if you operate on a broad notion of justification that takes reasonable conduct to be justified, rather than just conduct that does in fact perfectly meet the definition of the requirements of self-defense. Certainly the unreasonable mistake is something that takes whatever exculpation happens here into the territory of excuse. So that's true for self-defense and for defenses that are in any event conceptualized as exculpatory defenses, the same. What argument does Simister offer? Ultimately, he puts a lot of weight on the idea that the law still appears to instruct a person not to injure another, and that instruction is kind of going to still be there, even when at the same time the law seems to say to the person, but you may injure another person in necessary self-defense, or but you may be excused in a context where overwhelming pressure imposed on you, threat to your life, or to very serious injury leads you to act the way you have done, and there are some limits to what you've done. So that would be a rephrasing of duress. And it seems to me that that just leaves us with a gap in the argument. Ultimately, there is a gap in the argument, because even if one thinks that there is some mileage to this on notice notion, I don't see how that argument tells us, and therefore, in the case that somebody made an unreasonable mistake about the availability of a defense, all of what we've now talked about is cancelled, falls away, does no longer any work, and what we are left with is just that original offense. As if that person just shot at another person out of hatred or something, or because it's fun to shoot at people and they don't care about other people's survival. And it somehow isn't the same thing. Now, that it isn't the same thing was noted by some German criminal law scholars who, in terms of conducting the structured analysis, ended up at exactly the same point where Simister ended up. Oops. The justification has failed. The excuse has failed. What we have now, it seems, is liability for the original offense, and if that offense is murder, it requires intention to kill. Now, the German scholars who had analyzed themselves into exactly that same corner and did something that's very unusual for German scholars to do, they closed their eyes firmly and made an ad hoc fix to the problem they had stumbled on. They said, well, that's kind of the case, but the actual responsibility, the actual guilt of this person, surely is just the guilt of negligence. And therefore, we must now, even though we have the murder, punish it as if it was only a negligent killing. The law can stand in the way of doing that, but the argumentative move is also not entirely convincing. So what's going wrong? The more I think about it, I think the more what's going wrong here is this idea that what we do in criminal law, like in morality, is to take that instance of human conduct in the round. Because once you do that, then but you have already sort of structured your analysis in a step-by-step way that says definitional elements met, unlawfulness established, degree of culpability will be looked at now. You hold that definitional elements constant, but they never exhaust an assessment of what has happened in the round. The definitional elements, one instance of human conduct, as you will all know from your criminal law papers, can meet the definitional elements of a number of different offenses, right? And so the criminal law already takes this sort of very separated perspective on under what aspect are we looking at what happened here. And that, I think, is the best explanation for the move you need to make here, which is to say, when we are treating the fulfillment of the definitional requirements of an offense definition as completely preliminary. And if that conduct is not the best description of what went on, if that definition doesn't capture it, and it doesn't capture it, think of Duarte de Almeida's word, it doesn't capture it fully. We've already agreed there was so much else to bring up, so much else that does actually change our evaluation, our perspective on what is bringing up, even though it hasn't led us to say, you are completely excused, you're completely fine in what you've done. All these qualifications we cannot simply forget about. They should lead us to then move to a different offense definition that captures, in a sense, the gravamen of where you did X sort of goes all the way through as an accusation, even towards the end, perfectly. And often that will be the equivalent offense of negligence. And that is the best explanation for why, even in the context of an unreasonable mistake of fact, that then means that accessing a full defense fails, you should not punish from, and you should not treat as established that opening, that first offense you looked at, which was a crime of intent. You should see that as deflected, and you should instead see as established and punished for an otherwise equivalent crime of negligence. So I leave it here. That would be my talk for today.
Thanks. Thank you, Antje, and thanks for soldiering through that sore throat of yours. I could see that you were struggling at points. Right. I will open the floor to questions. And what I could do is I could get the ball rolling first, and you can also think of questions as we
This
go.
is, of course, so much the topic of your PhD that you can probably keep that ball rolling for longer than I have talked.
I will try not to monopolize the discussion. So it seems to me that you want to get rid of the concept of pro tanto wrong because Simister's argument for how he uses it doesn't work. But that is not to say that there can't be other arguments in defense of that concept, or indeed that there can't be other uses to which that concept can be put. So one way of thinking about this is to deny the claim that he did it must be an accusation. it can just be an ascription of responsibility such that it makes sense to ask for an explanation. So at that point, when you're trying to establish the authority to ask for an explanation, in one sense you've got to show that it's my business as the asker. So why is it my business what you did? Well, it should in some sense have at least apparently infringed on my interests or the interests of someone else. So it's no longer your own private business entirely. And that we can establish by reference to objective facts. Did what you do step beyond the narrow constraints of what is entirely your own personal business? Now we're asking this by reference to objective facts. When the response is offered, be that response a justification or an excuse, the response will be offered from a different perspective, not from the objective perspective, which seeks to answer the question, why is it your business to ask at all, right? It will be answered from the subjective perspective of the person who has been asked to give an account, an explanation. And that response can take the form of a justification, which is to say, look, I had perfectly good reasons for doing this. And it can take the form of an appeal or plea for an excuse, which says, look, I accept that what I did was wrong, but you should excuse me for these further reasons. And now what's happened here is a key shift from the move from the pro-tanto round, which we established objectively, to the explanation stage, which can be answered from a subjective perspective, a different perspective entirely.
Well, that's a different use of the label of pro tanto wrong, but I don't think that's an attractive one, because I can see you have now created a pro tanto wrong that doesn't even have the accusatory import, because it just focuses on, in the sense, a human being's presence in a causal sequence towards harm, right? That seems to be your idea of this objective thing that needs explanation. And it seems to me that in that context it is, for different reasons, and an even more unattractive label to use, because you haven't even quite reached the point where you would think of the wrong as something. But it gives me an occasion to clarify something that I left out of this presentation. So this idea that you did X, that you did it, the doing of it, in these accounts is invested with more than just a causal ascription. You know, the doing means the doing with some realization of what you're up to, with sufficient realization to actually, so it brings in a mental element of sorts, right? Mm-hmm. That was actually why, I mean, that is the completely different route through which the Germans, in a sense, arrived in the same corner as Simister. They had at some point realized that, I mean, when criminal law was assessed in your way, where the pro tanto wrong label really shouldn't feature, it was absolutely clear that an unreasonable mistake would have to count. And that was because in the first stage you just looked at the external facts, in a sense. Was so-and-so an entity that brought about a harm that is a criminally prohibited harm? And that doesn't tell you much. And then you looked at, was it justified? And then you looked at, or was it unlawful, the bringing about of that harm? And then you looked at, was it culpable? And all the mental elements went towards culpability. And it was only after it was accepted that, wait a minute, when we look at the definitional elements of an offence, we cannot just look at the actus reus part of it, the external elements. We actually have to factor in certain mental elements. And actually, Simister has a good account of that part, you know. He says that is also because the mental elements shape the scope of the prohibition. You have to organize your sex life in a somehow different way if liability arises whenever you interact sexually with another person, not reasonably believing that that person consents, compared to when you have to organize your sex life in a way that flags up to you only that once you understand that this person is not consenting, you mustn't act the way you do, right? So because it's partly because it goes to the scope of the prohibition that somehow you need to pack in a good chunk of the mental elements, including at least the natural intent to do what you're doing, into that first stage. And that then unbalanced what happened in cases of unreasonable mistakes that go to justification. Because you kind of had the mental element in place, and that meant that people were minded to think they had the wrong in place, at least some wrong. And that is exactly what I'm questioning.
Yeah, just a quick follow-up to that. So it's true that the way I frame it seems like we're talking about only the objective act elements as giving grounds to call for account. But it might be that the state in a liberal society might say, look, we don't want to ask you anytime you tread on someone else's domain to give an account. We will ask you in only some of these, in a subset of these cases. And so the mental elements specified, the mens rea state specified, will help us narrow down the cases in which we ask for an explanation. Now, the way you've explained it, where actual culpability is built in at the pro tanto wrong stage, seems to assume that we must we must understand mental states as true transcriptions of what actually happened inside the mind of the defendant or of the person asked about. But there is a different school of looking at this which says, look, we can't really ever know what's going on inside the minds of a person. What we can do is we can reconstruct as observers what looks like is going on, and if it looks like you pulled out a gun and you pointed at someone and pulled the trigger, then it seems like a sensible thing to ascribe to you an intention unless we know better. So now we are actually using a third person's perspective, an outsider's perspective, to say, does it look like you satisfied this label, mental state of intention? Does it look like you satisfied this label, recklessness? If so, we can ask you for an account. This isn't quite as susceptible to the objection that you made. So
but then you're just back where Simister is, and you say, well, maybe you can think of a pro tanto wrong as something that isn't even meant as an accusation.
That was the claim initially, right? I said that suppose we...
Yeah.
So the label we don't have to fight about, but if it's not an accusation, but rather a call for an explanation...
then let's just not deal with the label. I mean, to some extent, I think... what I'm interested in is, of course, a view that, first of all, says we need that notion to do some work. Okay? So now you have sort of introduced me to a way of using the notion without having... but officially saying it's not doing any work. Now, to that, my answer would be then that's a different but an even stronger reason to do without the notion, because then you just... Why don't you just say you met the definitional requirements of an offence and therefore, this is a basis for investigating further. But we're not even saying yet that we want to accuse you. And in fact, when Duarte de Almeida talks about the criminal law, this is a point he makes at some point, that we would actually build some responses into even a preliminary assessment and say, well, if on our preliminary assessment now looks like this may well have been done in self-defense, then it shouldn't even be charged, So it's not as if the accuser is necessarily committed to ignoring everything else. And certainly in a criminal law context, the practice should factor in what is known, including what is known about factors that go to potential exculpation at any stage, to whatever degree of certainty or uncertainty is acceptable at that stage. Yeah.
I was wondering whether...
Just for the sake of the online audience.
It's just for the online.
Sorry. I was wondering whether it all... So at the end of the day, I think the elements which are elements of the offence, and then you've got mens rea elements, circumstances, and justifications, I sort of feel like that they become in practice just a list of elements of the offence, as in, and you did this and it wasn't justified. And I think that you see differing in terms of within the criminal law, in terms of the definitions, any sort of rigour about what's a justification, what's an element of the offence, just isn't seen. So by way of example, in theft and in terms of an accusation, if you say you took my pen, I'm not sure that even it establishes a pro tanto wrong, I don't know.
Okay.
But whereas if you say you stole my pen, then you're introducing, perhaps most notably, in the absence of the justification that it was a claim of right. Because you're saying you stole my pen, therefore you took my pen without, with it being dishonest. Likewise, there's a difference between saying you hit me and you assaulted me. Assault may be incorporating the absence of self-defence. And I just sort of, and then duress perhaps is defined always as a justification, just because it's of such wide application, not because it's really very different.
So your question gets me into two further areas. It's a good question, actually, and it's a good question because of the way in which criminal law theorists have actually really struggled with this offense-defense distinction. What is it doing for them? Because there is one view in criminal law theory that says we should analyze everything that goes towards was this a breach of the law before we assess culpability, response, in that sense, as positive or negative offense elements. And in some sense, this is a good way of thinking about it. It doesn't track, as Duarte de Almeida pointed out, the practice that also exists of saying just having established the positive elements is normally all that we need unless we have reason to look for the absence of certain negative elements. And so that is sort of his, what shall I say, procedural take about a rule. So we are still dealing with a rule that has exceptions, and that is what it means to deal with a rule that has exceptions. But I think in terms of when do we have something in place that needs addressing because it's a wrong, it would be once we have assessed the unit involving both the positive and the potential negative elements, both the rule not falling under an exception in that context. And I think what comes about is when we sort of think back on the moral discourse and on whether a person did something that violated the law, that judgment is not compatible with saying they did it with permission. And so I think this perspective that says, yes, Antje hit Mark on the nose, which is bad, but she did so in defending herself against his attempt to hug her, which is whatever. Let's assume that generates a permission. Okay, so you can't have the two. You can't have action guidance. I mean, as action guidance, this is just a contradiction. Don't hit Mark on the nose, and you may hit Mark on the nose. What is it? So what it has to be in terms of wrongdoing, I think, but one can only ever work with a completed assessment of that part of things. There was another debate to which your comment speaks, but I've now forgotten what crossed my mind when you were speaking. So maybe it will come to me later.
I think we have time for one last question before we end here.
Okay, great, thanks. So I'm not trying to defend pro tanto wrongs or anything, but and the devil is in the details, and I don't know the details well enough. But is it possible that this notion tries to track our duties? So we are trying to say there is a duty not to fight. Okay.
Yeah.
Now, why is this important? it is not, it can be important for the law, being a law and a public institution, etc., to state to the public, without any connection to whatever it then tells about the particular defendant, but just to state to the public there is a duty not to fight. And maybe this is where it ends. So it is not necessarily saying anything beyond identifying the duties that we have.
I know where this is coming from in terms of, if you look at, yes, the criminal prohibition as such says don't hit people, don't hit other people on the nose, or don't hit people. It says that to everybody, says that to me. Now, in that specific situation, where that's the only way I can sort of counteract this unwelcome hug, it will be a question about whether in this specific situation, the law says to me, don't hit Mark on the nose, right?
You have a duty. You have a duty, and there can be a clashing duty, or there can be lack of culpability, or there can be many things in addition to the fact that you have a duty, which would change our assessment of the situation, even of the moral nature of your conduct. But still, we start with you have a duty not to fight.
No. In that situation, I no longer start there. I start with what I have a duty to do in that situation. And when in that situation, the law tells me, you may hit him on the nose, don't overdo it, he only wants to hug you. Then that's what the law tells me. And that means it actually retracts in that situation from any message to me that I have a duty not hit Mark on the nose.
Overall, you still have a duty not to. This is where he's coming from, because he's coming from the reasons discourse. Like Sinister is coming from the reasons discourse. And then the way to describe normatively the situation would be something like you have a duty not to hit Mark on the nose. There are some conflicting considerations. Maybe you have a duty towards yourself to defend yourself, maybe within the clash between these duties, the duty towards yourself to defend yourself overtops the duty not to, etc. But the statement is
discussion after dinner. But the point is, yes, the recent discourse is there, but it is part of what messes things up. That is because
you are saying you don't even have a duty
from legal reasons. Whether I have a duty is dependent on whether I have permission. If I have permission to do what I'm doing, then I don't have a duty not to do it, right?
Overall,
and I might still have a reason. But that reason is not, the law doesn't create reasons. I mean, that is not a successful, it's not a successful notion to work with reasons in the criminal law context. And why not? Yeah, of course, there are all sorts of reasons. Yes, there is still a reason. I mean, he has a pretty nose. There are all sorts of reasons why I shouldn't hit him, even though I have, in that situation, permission to do so. But that is not what the law is interested in, all these reasons, right? And that's a different debate about how criminal law theorizing goes astray when it switches from the notion of a norm violation, which is what it should be interested in, to the notion of reasons that are then now tagged and labeled in all sorts of ways: exclusionary reasons, excluded reasons, defeated reasons. It's not even a defeated reason that there's something about Mark's nose that shouldn't be injured or whatever, or shouldn't be blemished. But that doesn't matter.
Okay, Antje, I think we're going to have to call it to I was going to make a joke about it, but it would have been too on the nose. So we can continue the discussion in a more informal way outside, and I invite you to join us for a drinks reception afterwards. Thank you so much, Antje, for this wonderful lecture, and I hope you can join me.